Alright, everybody. This is a story that I think is going to hit a lot of you guys with a little bit of a... you're going to get T-boned by this one. You're going to be surprised. You may know that Florida, Texas, and a handful of other right-wing states have locally decided to require all porn websites to request age verification in the form of ID submission. You have to full-on, like, take a picture of your ID and send it in to get manually verified as a valid ID before you can watch internet porn. Which, of course, would also require that you have, like, an account. Like, porn couldn't be a thing that in those states you just throw up real fast, rub one out, and go on with your day. You know, you gotta make, like, an account on Pornhub and, like, verify your identity and stuff. And, you know, we've talked about these laws in Florida, Texas, etc. I think most of us, though, probably live in blue states. I know I do, and thus these laws are kind of like listening to stories about horrible disasters in third world countries. You just feel immense levels of empathy for the people involved, but you don't necessarily feel like you are at risk of such a thing. But I'd like to inform all of you today that you are. All of America is currently at risk of being subject to the exact same laws on a fully federal level. Right now, there is a Supreme Court case actively going on that will decide whether or not states will be required to force porn sites online to request a ID verification in order to access pornography. It's called Free Speech Coalition versus Paxton. And this is the Supreme Court case that will determine whether or not the porn ban becomes federal. Can states restrict online content in the name of protecting children? The Supreme Court will weigh in. On January 15th, the Supreme Court heard oral arguments in the First Amendment case Free Speech Coalition et al. Versus Paxton. I hate I don't know what that legal terminology even means, the et al. I know it's like Latin, right? So, I mean, it probably just means and. I don't know what it means after and. I don't know what al means, but it's Latin for something, I'm sure. The case involves the Free Speech Coalition, an adult industry trade group, in addition to several adult content companies and an anonymous content creator that sued Texas over a law that requires age verification on websites where at least 1/3 of content is deemed harmful to children, quote unquote, defined in the bill exclusively as sexual content. The law, HB 1181, primarily targets pornography websites, as the third rule affects sites with a significant amount of adult content while exempting search engines and social media websites. To comply with its age verification mandates, the law requires companies to implement methods that use government identification or private or public transaction data to confirm a user is over 18 years of age. Unlike Louisiana, the first state to pass an age verification law of this ilk back in 2022, Texas does not offer digital driver's licenses, meaning measures have to be implemented by third parties. Companies that fail to implement age verification measures in violation of the law can be liable for damages suffered by a harmed minor. The law also empowers the Texas Attorney General to enforce civil penalties of $10,000 per day on sites out of compliance. Originally set to go up into effect on September 1st, 2023, the law was blocked by a district court. After the state appealed, the U.S. Court of Appeals for the Fifth Circuit reversed the preliminary injunction. However, it found that a provision in the law that required a disclaimer about the perils and potential harms of viewing pornography to be displayed was compelled speech, keeping it enjoined. The Fifth Circuit's decision paved the way for Texas Attorney General Ken Paxton to sue several adult websites in early 2024. So yep, it's Ken Paxton versus porn sites. That is what this entire case is about. And while it may be an escalated to the Supreme Court case in regards to Texas, we know how Supreme Court cases are. If the Supreme Court makes a decision favorable to Attorney General Ken Paxton, that sets a insane legal precedent. The power of the Supreme Court when it comes to claiming a precedent has been set and thus should be followed, because the Supreme Court did it, is very powerful. And in future legal battles in potentially purple or blue states in the future, this Supreme Court precedent will be used to determine how that turns out. If this goes in Ken Paxton's favor, a lot of America could be subject to the same to these same laws, potentially a federal law passed by Trump or passed by his administration. Man, it sure isn't worrying at all how much of Trump and the Republicans' motives centered around collecting names and addresses for people that they can associate with groups that they politically don't like, such as gay people and autistic people. I just think that's interesting. What's at stake in this case? The Supreme Court agreed to take up the case in July 2024 after the Free Speech Coalition appealed the Fifth Circuit decision. The court's decision in Free Speech Coalition versus Paxton will have nationwide implications as 19 states have passed age verification laws, many of them similar to Texas's law. Yet the Supreme Court's review isn't litigating whether age verification laws are constitutional, though that debate will be back in court down the line, but rather how these courts should evaluate these and other content restricting laws in the context of the First Amendment. That's right, this is not the only case in which something like this is going to happen. I discovered a loophole. Social media sites, they just said it's if a site has at least 1/3 of its content determined to be pornographic, it is subject to this law. Social media, it doesn't matter if it's a social media site or not. If 1/3 or more of its content is pornographic, it's subject to the law. That is the standard they set. They explained it just a minute ago. That is their standard. Yeah, that does mean websites like DeviantArt and Tumblr are on the chopping block. Twitter as well. There's a lot of porn on Twitter. Twitter is totally on the chopping block as well. They are not safe. So Twitter is cooked? I hope so. Reddit? Oh, yeah. Aren't there, like, dedicated porn subreddits? There's gonna be at least 1/3 of Reddit that's porn, right? It's gotta be at least 1/3 of Reddit that's made up of porn. I feel like more than 1/3 of the internet has to be porn. We all know the song, right? The internet is for porn. Like, we all know the song. Like, we all know it. It's gotta be at least 30%. Like, most of the internet is going to be fucked if this passes on a federal level. Blue Sky has it as well? I had no clue Blue Sky had it. Well, damn, I need to use Blue Sky more, apparently. I'm missing out. Quote, we think this case really is about what's at stake and is what is I can't speak today, good lord. We think that this case really is about and what's at stake is what does the government have to show to a court to justify a content-based regulation of speech, said Vera Edelman, a staff attorney at the ACLU Speech, Privacy, and Technology Project. The ACLU is representing the Free Speech Coalition as co-counsel. When the Texas District Court initially enjoined Texas's law, the judge applied strict scrutiny, the most rigorous standard for reviewing laws that affect free speech rights. Under the strict scrutiny standard, a law must be narrowly tailored, further a compelling government interest, and be the least restrictive option. The district court concluded that the Texas law was overbroad, and imposed excessive restrictions in granting a preliminary injunction. I need to zoom in on this page a little bit, because this text is a bit too small. On appeal, however, The Fifth Circuit ruled the law only had to satisfy the rational basis standard, a lower level of scrutiny applied to laws that do not infringe on fundamental rights. In applying rational basis, the Fifth Circuit argued that the law did not imperil the free speech rights of adults. And since the law was related to a legitimate government interest in preventing minors access to pornography, quote-unquote, the court found it to be constitutional. In this case, the specific question before the Supreme Court is, quote, what level of burden can be enforced on access to free speech in the name of protecting children from viewing pornography? Ultimately, Free Speech Coalition vs. Paxton asks what kinds of restrictions the government can put on free speech under the banner of protecting children. So essentially, what the core of this is, will a precedent be set that free speech isn't good if it means that it can be proven or argued in court that children are being harmed if free speech is being allowed? They are unironically trying to set a legal precedent that it is okay to be anti-free speech if they can justify it by saying they're protecting children. That is what they are fighting to set as a precedent right now. What could be the impact? The Supreme Court will deter... God, I can't read today. Nor can I speak. I've got such bad mush mouth. I hate it. The Supreme Court ruling will determine which level of scrutiny should apply to the Texas law, rational basis or strict scrutiny. It's unlikely the justices would rule that intermediate scrutiny applies, the standard between rational basis and strict scrutiny, but it's not out of the realm of possibility. The justices will either make a decision themselves about whether the law satisfies the level of scrutiny, or remand it to the Fifth Circuit. If Texas's law ultimately satisfies either strict scrutiny or rational basis, the implication would be that laws regulating protected speech can be implemented if they further a government interest and do not infringe on adult speech rights. It would impact future cases involving pornography in particular, as the law uses a modified Miller test to determine whether content is obscene to children specifically. Although pornography is legally distinct, what is a Miller test? Mailed 5 unsolicited brochures to the manager of a restaurant and his mother containing explicit pictures and drawings of men and women engaged in a variety of sexual activities. Mr. Miller was prosecuted for violating a... based on the Miller test, this is what qualifies as pornography. 1. Whether the average person applying contemporary community standards would find the work, taken as a whole, appeals to the prurient interest. 2. Whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. And 3. Whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So that basically, like, nudity in a painting would be fine, but, you know, the kind of shit made to get off to wouldn't be allowed. Like, they've got a definition that seems to pretty much just narrow down on, you know, porn. I found the song Zan was talking about. It's right. Huh? What song was I talking about? Oh, the Internet is for Porn song? Oh, okay, that's what you were looking for. Okay, I got confused. That was a minute ago. Hey, what song did I mention? That one? Okay. Anyway. The justices will also either make a decision themselves about whether the law satisfies the level of scrutiny, sorry, I already read that bit. However, regulating certain content because it can be viewed by a child could fundamentally change how users freely access information, especially information that has come under attack from the government, such as reproductive health, LGBTQ+ resources, and books about sexual assault. As Lee Rowland from the National Coalition Against Censorship noted in an ACLU briefing, minors are not monoliths, and what is inappropriate for a 5-year-old might be fine for a 16-year-old. But legislatures may not or may fail to make such distinctions, and a favorable decision for the Texas law could open the door for any manner of content restrictions as long as they apply to children or minors and further a government interest. I think it's really important to remember the right are very calculated and malicious in everything they do. They really are. I think there is a reason, one core reason beyond every other that you can imagine, why the right so frequently likes to use children as a weapon in their arguments and their rhetorical debate strategy. if they can make the conversation about how they want to protect children from the outside looking in, or very easily with outside framing, it is a conversation that looks like one party whose goal is to protect children, and another party, like, unequivocally, the conservative wants to protect children and does not want them to be endangered in any way. And to the average onlooker, the other party arguing against the conservative looks like they are, in some way, shape, or form, making excuses for children getting hurt, or trying to argue it's good or worth it or fine. And so when they make the conversation hinge around this concept, and you disagree with them, but what they're saying is so loud and proud about how their only goal is to protect children, it looks like you have a problem with protecting children. It's not just a defense strategy, it's an offense strategy. It's an offense strategy where you hang yourself with the rope they give you. And I think that's where a lot of this, hyper-focusing on using children as the weapon in political engagement, I think it comes down to that. They want to be able to, frame the conversation in a way that defaults you into the bad guy position. However, moreover, if the court decides that the law satisfies strict scrutiny, it could mean that the courts find the 1/3 rule as narrowly defined. So this is another way the law could not make it through. The Free Speech Coalition has argued that the classification is vague. Does it mean 1/3 of the pages on a website, or 1/3 of all hosted media, and can apply to content other than pornography, such as conventional cinema or romance books? While it is unlikely that state attorneys general would pursue litigation against companies like Netflix or Barnes & Noble based on the 1/3 limit, which at least in another state bill that passed was lowered to 1/4, could lead many businesses to remove content or implement broader age verification methods. The courts, in blessing the Texas law based on strict scrutiny, would also need to view age verification as the least restrictive, quote-unquote, method, a shift that could influence proposed legislation and legal precedent. In 2004, the Supreme Court ruled in Ashcroft v. ACLU that the Children Online Protection Act's age verification requirement was too restrictive, given other available options like content filtering. In more recent years, public information campaigns and device-based age verification have been floated as less onerous means than sharing identifying information each time a user visits a website. Several briefs filed on behalf of the Free Speech Coalition by technology nonprofits, including the Center for Democracy and Technology, New America's Open Technology Institute, and Electronic Frontier Foundation, pointed out the privacy risks of age verification. On the other hand, if the court decides the law does not pass strict scrutiny, if the opinion is written too broadly, it could become a roadblock to any sort of legislation that attempts to protect children online. This is a scary thing as well, because it's not just that, what if this law succeeds? What if this measure succeeds and we lose a bunch of freedom and privacy? It's also, what if it fails and that precedent is used in the future to stop laws that actually do protect children online? Because well-made, meaningfully constructed, and well-meaning laws designed to protect kids from, online predators and things like online gambling and popular games played mostly by kids. There's a million areas in which we need laws to protect children online. Getting advertised to, having gambling advertised to them, getting hooked on gambling. A lot of it involves gambling. Protections for... I think parents should be able to sue someone if their child is, groomed through an online game. If a game facilitates a gamer to, groom a kid or something, there should be a legal precedent for parents to seek a settlement from the company, the multi-billion-dollar company that allowed that to happen on their platform. There should be laws constructed around the concept of the internet, like we have now, that are centered around civil litigation, criminal litigation, Like, these are areas that need to be explored and laws need to be passed. And if this fails, which is the good ending, that might be harder to do in the future. The Republicans are essentially using a window of opportunity where a good law could have been passed to pass a bad law that, if it passes, will hurt everybody. But even if it fails, it will hurt the ability for another law similar to it but good to actually make it this far in the future. So it's bad on either side of the fence, basically. On the other hand, quote, there is a real danger that some litigants will use a decision against Texas in this case to argue that any privacy or platform design law that involves any age assurance method is categorically unconstitutional, Epic continues, later referencing NetChoice, the technology trade union behind legal challenges to the California Age Appropriate Design Act and lobbying against the federal Kids Online Safety Act. It is commonly agreed that age verification technology is much more sophisticated than in the days of Ashcroft v. ACLU, and the internet has massively changed over the past 2 decades. Epic thus urges the justices to not mechanically apply indistinguishable precedent in this case, and instead demand that the lower courts base their decisions on a robust record reflecting the current state of technology. The brief notes that opinions could help or hinder future content-neutral laws aimed at making the web safer for children. The Supreme Court is expected to issue a ruling in June or July this year. I had some people dooming in my Discord server about how this ruling might potentially go. Literally earlier today, I had people in my Discord dooming about it. And listen, this is some scary stuff, don't get me wrong. But I will say that the Supreme Court, as bad as they are, as right-leaning as they are, they have been making some pretty surprisingly based decisions lately. And there is a good chance that we don't get fucked over by them on this. Maybe I'm being naive, but I see no point in dooming over it until we know we're going to get bad news. All we're going to do is give ourselves anxiety and stress. Let's just hope for the best and be ready to prepare for the worst. Anyway, if you watch this far into the video, I want you to comment down below. Here's what I want you to comment. Gooners rise up. Comment down below, Gooners rise up, if you watch this far into the video when it goes out on YouTube. I want to see all the Gooners rise up comments. And of course, if you enjoyed this video and you want to support my channel, because it's totally free to do so, consider leaving a like by hitting the thumbs up button, or hitting the subscribe button and the comment button as well. Like I said before, liking and commenting really helps a ton. Make sure you subscribe and ring the bell icon so YouTube actually tells you when I go live or upload new videos in the future. Follow my social medias linked down below in the description if you haven't already, so you can see more from me on other platforms. And if you want to help me keep the lights on and a roof above my head here at the Xander Hall studio, then consider supporting me financially by donating, subscribing, or gifting a sub on my website, xanderhall.com/live. Or you can support me through YouTube, Twitch, Streamlabs, Stream Elements, Patreon, or you can buy some custom Xander Hall merch from the Streamlabs link down below in the description. Regardless of how you support me, though, thank you so much for watching, as always, and have a good one.